One more. I forgot to record.
Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So I'm kind of conflicted. If you've watched my videos, you know that I don't think that Hannah Gutierrez Reed was culpable in the death of Helena Hutchins because she didn't pull the trigger and her negligence was there was supervening negligence on the part of Baldwin in pointing the weapon at Helena to begin with. And while you can trace it back to her putting live ammunition in the gun, at some point it becomes the responsibility of Alec Baldwin. And I didn't think the judge did a very good job of keeping control of things in that case. In fact, I found the judge to be sort of a dour person who just really wasn't pleased by anything. I can't imagine anybody ever baked a birthday cake to her satisfaction. But at any rate, I'm conflicted because while I think that Morrissey was probably not the nicest person in the world in the Hannah Gutierrez Reed case, she is now up against Quinn Emanuel in the Alec Baldwin case, and she has the same judge. And I am now a big fan of Ms. Morrissey, and I'm also a big fan of the judge because she got it right on the motion to dismiss the indictment. And we'll take a look at that now. So this is the order denying the defendant's motion to dismiss the indictment, and it starts with a procedural summary. And the important parts here are that on May 17th, the court entertained oral argument on the motion to dismiss. And that was a very long and much greater, she gave the parties a lot more time at oral argument than I have seen most judges do. And I think that's good. I think both parties should have a reasonable opportunity to present their cases, even though sometimes lawyers have a tendency to beat a dead horse. And I think that's kind of what Baldwin's attorneys did. But again, I have to admit I'm biased against those attorneys in this case because I do think Baldwin is primarily responsible here. And then she goes into the factual background regarding the motion to dismiss. In advance of the grand jury presentation, the state filed two motions. One motion concerned whether the state had to present target-offered evidence to the grand jury, and the second motion concerned whether the state had to provide target-requested jury instructions to the grand jury. As to the first topic, ultimately, Honorable T. Glenn Ellington, in his role as the grand jury judge, instructed the state to alert the grand jury to nearly all of the evidence set forth in the target's evidence letter via Judge Ellington's order on the motion. And then it says he struck a portion of the target's evidence as being argumentative, meaning that in the letter they made reference to certain witnesses or something that he thought went above just identifying the evidence and went more to arguing the evidence, so he struck that from the letter. So the prosecution was required to read this letter to the jury, to the grand jury. On the second topic, the state filed its motion to exclude the target's requested elements instructions to the grand jury. So Judge Ellington entered an order on January 11th, granting in part and denying in part. On the January order to exclude the instructions, the court granted the state's request to exclude the target's proffered criminal negligence standard instructions. In addition, Judge Ellington's order addressed the state's concession that the state would present to the grand jury and cautioned the state that it must provide this standard jury instruction if the evidence supports its provision to the grand jury. Then on January 11th, in its order on the state's motion to exclude, did not address other substantive instructions for provision to the grand jury. So on January 18th and 19th, they held the grand jury, and after the grand jury considered witness testimony, the state provided the grand jury with instructions based on the following uniform jury instructions or applicable statute and modified to reflect the probable cause standard assessed by grand juries. A jury instruction in a criminal case requires that the defendant be found guilty beyond a reasonable doubt. But in a grand jury, The grand jury merely has to determine whether it's more probable than not probable that a crime has been committed and that the person to be charged committed that crime. They have all these instructions here. It says, following the state's presentation and instructions on January 19th, the grand jury returned an indictment against defendant charging count 1, involuntary manslaughter, negligent use of a firearm, and alternative count 1, involuntary manslaughter without due caution or circumspection. And the defendant now challenges that through the motion to dismiss. Analysis and ruling. First, defendant argues the state exhibited bad faith. Second, the defendant asserts that the state withheld exculpatory and favorable evidence from the grand jury. Third, defendant contends the state provided an inaccurate jury instruction. Defendant asserts the state failed to advise the grand jury of its authority to order the presentation of evidence and witnesses beyond those offered by the state. Fifth, defendant argues the state failed to follow the instructions of the grand jury judge. And finally, the defendant contends that the state's response constitutes a waiver. And in some respects, I'm actually inclined to agree with the defendant here that it is never a good idea to waive any kind of argument that you may have by not citing authority. And that's essentially what they accuse them of. But the judge, in this case, forgives that technical deviation. So she summarizes the law on challenges to grand jury indictments, and she says there's only two ways that they can be challenged. One, challenge to the quality or sufficiency of the evidence before the grand jury, and then two, structural challenges involving the manner in which the grand jury process has been conducted. With respect to structural challenges, if the prosecutor does not strictly adhere to the grand jury statutes and procedural rules designed to protect the target's rights and ensure the fundamental fairness of the proceeding, the structural integrity of the grand jury process is compromised along with the grand jury's determination of probable cause. And they cite to Herrera. The judge then goes on to point out that they've found structural violations in several cases. In Herrera, it was when the prosecutor unlawfully prohibited a target from providing testimony in response to a grand juror's question. In the next case, the prosecutor excused grand juries about involvement by the district court. In the next case, the court determined that a prosecutor's failure to instruct the grand jury on the record of the essential elements of the offense constituted structural error. Fourth, in Baird v. State, the New Mexico Supreme Court found a structural protection violation when the prosecutor was amongst the grand jury during its secret deliberations, because the prosecutor's not supposed to be in there. Fifth, in Davis, the structural error was unauthorized individuals being present during grand jury presentations. And State v. Pareo, the New Mexico Court of Appeals found a structural violation when the prosecution did not afford the defendants their right to testify to the grand jury and inadequately instructed the grand jury regarding that right. So other than the two categories of challenges above, New Mexico appellate courts have limited other substantive reviews. Neither the legislative nor judicial branches permit judicial review of the quality or quantity of evidence considered by a grand jury. So essentially, if you don't have a structural error or an error in bad faith, then you don't have a challenge. So the court did not find prosecutorial bad faith, which it defined as dishonesty of belief, purpose, or motive. The judge says it appears to address bad faith in presentation to the grand jury, such as deceiving the grand jury as to the probative value of the evidence, but not bad faith in the initial acquisition of probative evidence that may be subject to suppression at trial. So, for example, you have a search made by a police officer that may not necessarily be according to Hoyle, and they find drugs. But the prosecution likely knows that because of the way the search was conducted, they're probably going to get a motion to suppress once the indictment is filed and this case goes live. But they don't tell the jury that that evidence might be excluded. That's not a violation, and it's not bad faith. The court could not find, and the parties do not offer, additional authority defining prosecutorial bad faith in the context of grand jury presentations. And the court does not find that the defendant has established prosecutorial bad faith. In other words, after reviewing the transcripts from January 18th and 19th, the court does not find that the prosecuting attorney assisting the grand jury engaged in intentional misconduct reflecting dishonesty of belief, purpose, or motive in the course of the attorney's presentation of evidence to the grand jury. With regard to bad faith, that's out the window. The court does not review the state's decisions regarding evidence presented to or excluded from the grand jury. And the defendant argues that the indictment has to be dismissed because the state withheld exculpatory and favorable evidence. And in support, they claim that the state was required to elicit exculpatory testimony from Halls and Souza. And she was also required to provide the grand jury with specific documents identified in Baldwin's alert letter that reflect these and similar exculpatory statements from both witnesses. The court disagrees with the defendant for three reasons. First, the defendant conflates a prosecutor's duty to alert the grand jury to target offered evidence with a prosecutor's discretion to present exculpatory evidence. And the courts have found that the amendment in 2003 eliminated the prosecutor's duty to present evidence that directly negates guilt. Therefore, the court concludes that the prosecution was not required to present and the grand jury was not required to order target offered exculpatory evidence. Second, as decided in State v. Zhao, the prosecutor has broad discretion as to what evidence to present or exclude from the grand jury, and the courts don't review those good faith decisions. And finally, redirecting the grand jury's inquiries to her own witnesses. So this is kind of interesting. This is what happened here. And I'll go into this and we'll skip it in the part. But basically what happened is you'd have a witness who was testifying. For example, Mr. Halls. And the grand jurors ask a question. And they say, what about this? And the prosecutor says, well, you know, Mr. Halls is not really the best person to answer that question because we have experts who are going to answer that question for you. And when they come in, you can ask that question of them. So she didn't let Halls answer that question, which is perfectly appropriate. While the court acknowledges defendant's argument that Morrissey diverted the grand jury from hearing exculpatory evidence, redirecting grand juror inquiries to her own witnesses, the court does not find this amounted to structural error. That's because Herrera did not directly address that. And in addition, the prosecutor's action in Herrera had the effect of chilling additional questioning. And here, regarding the instant case, in at least 5 separate instances, the grand juror posed a question to a witness who the prosecutor considered not qualified to answer, and that she can do that. In addition, the New Mexico Court of Appeals explained, we understand Herrera to require an assessment of the prosecutor's actions viewed under the totality of the circumstances, and under the totality of the circumstances here, there was nothing wrong with that. Although the state deferred certain questions, in many other instances, the grand jurors asked probative questions and received complete answers from witnesses without state interference. Therefore, the court concludes the prosecution's deferral does not constitute structural error. The court does not find error with respect to the contested jury instruction. And here that's because the instruction said, the target discharged a firearm during the production of a movie without first verifying the firearm contained no live ammunition and while the firearm was pointed in the direction of another. Well, when a uniform jury instruction exists, that has to be used, and in pertinent part, modified for furnishing to a grand jury, the instruction from the state says, for you to return an indictment, you have to find there's probable cause to believe each of the following elements of the crime, and then they go through the elements of the crime. Here, the court does not find error in the state's construction of the element of one of the involuntary manslaughter instructions. The instruction alleges the commission of a lawful act which might produce death without caution and circumspection. So they met the requirement of the jury instruction, and they met the case law requirements for giving that instruction to the grand jury. So that claim fails. The court concludes that the prosecution adequately advised the grand jury with respect to the target's evidence alert letter. In most states, you don't have a right to go in and present a defense to a grand jury. In other words, it's the prosecutor's show. It's only their show, and they have pretty much full reign over what goes on. It's been said that, of course, the prosecutor could pretty much get a jury to indict a ham sandwich. but I think only if it didn't have mustard. That's my personal preference. Anyway, specifically, the defendant states Morrissey never explained the meaning or practical significance of Baldwin's alert letter, why it was being read into the record, or what the grand jurors were supposed to do with it. Well, in New Mexico, they have this thing called an alert letter, and it's a letter that the prosecutor is required to read to the grand jury. And basically what it says is, hey, I'm Alec Baldwin, and these are the things I think you need to know. There's a witness who will testify to this. There's a witness who will testify to this. There's a witness who will testify to that. And then it identifies the witnesses and says to the grand jury, essentially, these are the witnesses and this is the evidence that we have that supports you not indicting our client. Well, pursuant to the statute, the target or his counsel may alert a grand jury to the existence of evidence that would disprove or reduce an accusation, or that would make an indictment unjustified, by notifying the prosecuting attorney who is assisting the grand jury in writing regarding the existence of that evidence. So and basically what they're saying here is, well, she didn't tell them what the purpose of this alert letter was. Well, the form of the jury instruction regarding target letters says it includes this preamble, generally advising, in accordance with the rights and obligations of the grand jury under New Mexico law, the above noted target of the grand jury proceeding in this case requests the grand jury consider the following evidence. Here the state read the target's evidence letter verbatim to the grand jury. After receiving this letter, the grand jury opted not to consider additional evidence offered by then target. So, indeed, the grand jury is not even required to hear the evidence once it's made aware of its existence. And that's what the state law and the court decisions hold. Evidently, after the state read the target's evidence letter, the grand jury decided not to order production and presentation of the target's evidence. The court is not in a position to second-guess the grand jury's decision in that regard. And finally, the court does not find that the prosecution violated the instructions of the grand jury judge. The defendant expounds upon the defendant's arguments concerning the state's compliance with the judge's order. And as to whether witnesses were made readily available by the prosecutor, the judge's order said, the court declines to instruct the state on the logistics of securing the availability of the target's alerted witnesses and tangible evidence. And so what they're complaining about is, well, you never made these people available. They weren't sitting outside the grand jury room ready to testify, and for that reason, there's a structural error. But given the language of the order, the court concludes the prosecutor did not violate the judge's instructions. So finally, we come down here to the court rules on the merits of the defendant's motion to dismiss. Defendant asserts the state responded with a 32-page jeremiad against Baldwin and his lawyers that does not cite a single legal decision, does not distinguish Baldwin's authorities, and spends no more than 5 pages addressing the core legal issues raised in Baldwin's motion. Further, the defendant concludes that the state's failure to distinguish his authorities constitutes a waiver. This is dangerous, and lawyers should not do this. If somebody cites legal authority, you either distinguish it or you ignore it at your peril. And if you ignore it at your peril, you can't be surprised when it bashes you upside the head in a motion to dismiss. But in this case, the court says, the court declines to grant defendant's motion to dismiss on grounds of waiver. New Mexico case law recognizes a strong bent in favor of deciding matters on their merits. Accordingly, the court addresses defendant's motion to dismiss on its merits. It is therefore ordered that the defendant Alec Baldwin's motion to dismiss the indictment is hereby denied. Well, that's a good ruling, in my opinion. That's where we are with this case. It is now going to go to trial in July. I intend to do a video on this pretty much every day that it comes up because I think this is a tremendously interesting case, and I think, as I've said before, that Baldwin is culpable in this case. But only the jury gets the right to make that determination, and only the jury should make that determination. So that's what I have for you today. If you have the opportunity today, please go out of your way and do something nice for somebody. You know, when we work an act of kindness in favor of someone else, we just do something nice, it makes the world a better place. And we could all benefit from the world being a little bit better place. So, as I said, that's what I have for you. Please, after you do a kindness today, come on back down here tomorrow and join me at the beach, and we'll talk about something else interesting.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.